I've got to set this up. This is all about money in politics, and anybody who listens to this show knows that's something that I have very strong, very consistent feelings about. I've been saying since at least 2004 that I believe what we need in this country is a restored democracy trifecta. That's public financing of elections and, if possible, free TV ads to take some of the money out of the elections, and then media reform, less concentration of ownership, and more fact-checking. And it's funny, I've noticed lately there has been actually a rise in that. Some TV shows are beginning to fact-check online, something I've been advocating for about 6 years. And finally, election reform. And that is the simplest piece of that is just to make sure that we have auditable, verifiable, accurate, safe elections. And then there are a number of other election reforms like instant runoff voting and so on, which would even, I think, contribute to making things, as I say, more democratic. That's democratic with a small d, which is, I believe, the only thing that will save us from this money-driven politics that we now have. And let me just share a little bit of my feelings about that. I will say to people very often that this age of Obama, since Obama's election, I am actually more disheartened, more saddened than I was during the Bush years. The Bush years, clearly, that was someone who did not have a progressive perspective, and, you sort of fought what you could and hoped for unseating him and his party. Then Obama, perhaps the brightest, most able, most politically astute candidate we certainly have had since Bill Clinton, and a groundswell of public support elects him against great odds, and now we have to deal with what happens when the most progressive candidate wins. And what we have found in the case of health care, the most obvious, the most long drawn-out case, but we're seeing tough battles on financial reform. We're going to see very tough battles on anything that has to do with climate and energy, and so on. What you saw in healthcare, which I think is a microcosm of the method here, is that when it comes down to it, having majorities in both houses, which will likely fade away or diminish in the 2010 elections, which just happens all the time, especially when you're in a recession, but having those two majorities and having a Democratic president who espouses progressive goals, what you see then is that the goals shrink, the policies shrink, and they shrink because when you throw something to Max Baucus in the Finance Committee to be one of the main arbiters of your health care reform, something which I've said on the air many times, an amazing statistic, Max Baucus gets 13% of his contributions from the state of Montana. The other 87% come from his real constituents, the folks who have business with the Finance Committee. And what you see then is a diminution of the original policy goals. And I think it actually ends up worse, because what you see in this country is, I think, the people, whether there's a recession or not, the people in America like winners. They like people who stick to their principles. They like people who stick to their guns, who stick to their convictions. And what you have is one party in this country, the Republicans, who actually are against government for the most part. So there's 50% sort of your, or some, number like that, of your political energy in this country. Other people from other countries are amazed at this, where you have a party and a whole bunch of, as I say, political energy that is against government. But their goals agree with their funders. So when the Republicans say, we want to score a touchdown, their funders say, go, and they're aiming for the goal line. What I have seen over and over again is that you may elect a Democrat in the most cases, with some exceptions, who says, I share your policy goals. I think we need cost controls in health care. I think we need a public option. I think we need climate change legislation. I think we need to rein in the Wall Street investment banks. And so they'll say, I want to score a touchdown too. But then their funders will say, we really want to only go to the 25. And so you then have one party that is gung-ho, in step with its funders, going for the touchdown, and you have another party, and the people see this, and the people smell it, and the people just don't like it, that is constantly negotiating with themselves. They're negotiating within committees, they're negotiating blue dogs against red dogs, and they're even negotiating, I think, within themselves. between what they really want, why they originally got into politics, and what their funders want. And until we get the money out of politics, this is a system which really handcuffs us in taking on the big challenges in this country. Grant Davis Denny is an associate in the Los Angeles office of Munger, Tolles & Olson, one of the most powerful firms in California and the United States. In addition to his commercial litigation practice, he maintains an active pro bono practice. He's represented members of Congress, Common Cause, and international election law scholars in filing amicus briefs in the U.S. Supreme Court. He has represented death row inmates in a successful challenge to California's lethal injection regulations based on the Department of Corrections' failure to comply with the Administrative Procedures Act. And he currently represents the Clean Elections Institute in its defense of the Arizona Citizens Clean Elections Act. Welcome, Grant Davis Denny.
Thank you very much for having me on your show.
Okay, I'm sorry I went on so long, but this one gets me going.
Well, I appreciate your commitment to covering issues about money and politics, and I really agree with your comments up front. I mean, I became politically active back in college, and when I first got active, I took a look around and I was sort of overwhelmed by the number of issues that one could work on, and I was really struggling to figure out where would I spend my time. And I led up an organization at Kansas State University called the Progressive Coalition. We weren't a large organization, but we were there.
This was the Kansas that Thomas Frank looks back on.
That's
maybe.
right.
Yeah.
Maybe. I'm not sure I'm that old, but anyway, we one day I invited a professor to come in, and I told him you can talk about any issue you want to, and I assumed it would be healthcare reform or environmental protection. He chose campaign finance reform, and I thought, that's a rather bland topic to choose, but okay, we'll give it a shot. And he came in and gave a very compelling presentation on, if you care about those issues like environmental protection, healthcare reform, economic and social justice, dedicate your time to campaign finance reform, because that is the gateway issue to achieving progress on so much of what we care about.
Let me cut in for a second.
Sure.
I have said many times on this program that my almost facetious, although I wish it weren't, recommendation is that everybody who's it's so funny that you say this, because you and I didn't talk about this before we went on the air. If your issue is environmental, if your issue is healthcare, if your issue is don't ask, don't tell, whatever your issue is, if your issue is cutting the defense budget, if all of those single issue people would join up and put all their energy into political finance reform until they get something meaningful passed, that would be probably the best thing they could do for any one of their issues. And otherwise, we find ourselves playing defense repeatedly.
I think that's absolutely right. And we've seen it in states that have adopted clean elections, which is, we can talk more about it perhaps later in your show. But, this is a system of public financing that gets big private contributions out of the scene. And we've seen in those states that have adopted it that you see these very progressive environmental protection policies, more ambitious prescription drug benefits, all across the board. If you care about progressive issues, spend time on campaign finance reform too.
Absolutely. I mean, it really is. We are so in sync on this. I'm Terrence McNally, and I'm speaking with Grant Davis Denny. He's an attorney with Munger, Tolles & Olson, a former chair of the board of directors of California Common Cause, and a very active expert and advocate for public financing of elections. And if you agree with us that this is something you want to know more about and get more involved in, I'm going to name 3 websites. One is CA Clean, one word, California Clean, caclean.org. Another is commoncause.org. Wherever you are in the country, there is a national common cause and there are a state common cause. And Common Cause is for making power accountable to the people. It's very much nonpartisan. And, in fact, they were very enthusiastically behind the redistricting commission in California, the ballot proposition which passed, and which means that this time around, following the census, our congressional districts will be chosen not by incumbent legislators, but by citizens, and Common Cause did that, and incumbents from both parties didn't like the idea. And then yes on prop15.org. Yes on Prop 15, one word. Prop 15 is a sort of pilot program of clean money elections that will be on the ballot June 8th in California to bring that, at least on a trial basis, to the state of California. Let's talk first for a few moments about Citizens United. That is the case in which the Supreme Court removed many of the limits on corporate contributions to political campaigns. I'm sure you've talked about it many times. You probably do have it down where it doesn't take nearly as long or sound nearly as abstract as it might. What was the case? What was the Supreme Court's behavior in bringing it toward, and then what was the decision?
Well, Citizens United, in my view, is a case in which 5 activist conservative judges converted a case about a very narrow set of issues into an opportunity to overturn settled precedent, upend federal campaign finance law, and adopt a view of democracy that accepts the notion that it is okay for big money to buy access and influence in Congress. Just a bit of history here. Since 1907, Congress had required corporations who wanted to spend money in federal elections to do so through separate segregated accounts. They couldn't use their treasury accounts. It didn't prohibit them from speaking or even spending money entirely, but it required that if they wanted to go out and spend money, they had to raise contributions from willing shareholders and willing employees. They couldn't take money from their massive treasury accounts to influence federal elections. Congress repeated that view in the 1940s when it passed the Taft-Hartley Act. Congress again in 2002 when it passed the Bipartisan Campaign Reform Act took the same view that corporations should not be able to use their treasury accounts to influence federal elections. Back in 1990, the Supreme Court upheld a Michigan law that basically did the same thing, telling Congress you could keep doing what you've been doing. In 2003, the Supreme Court again considered the issue and again upheld the ban on corporations using their treasury accounts to influence federal elections.
And as you point out, in each of these cases, they are upholding previous precedent.
That's right.
They
following
are
previous
being
precedent.
Conservative, following previous precedent.
That's right. And there are 2 fundamental issues that you have to understand about how courts typically operate. One is that appellate courts, like the Supreme Court, typically don't consider issues that weren't raised in the trial courts below, for a very good reason, because litigants should have a chance to develop a record of facts below. Remember, when people go up on appeal, it's just about pure legal issues, and you have to take the factual record that was developed below as a given. But if people aren't given a chance to develop a factual record below because they don't know that this issue is an issue in the case, they're robbed of that opportunity. Second key principle that people need to appreciate about how courts typically operate, and in particular the Supreme Court, that is the principle of stare decisis. You respect settled precedent. There may be occasions when precedent is wrongly decided, it is proven unworkable over time, it's inconsistent with an entire body of case law, but it has to be exceptional circumstances before the Supreme Court will go back and reverse its own decisions. The Supreme Court violated both of these principles in this case. They took a case that was originally about whether the ban on corporations using their treasury accounts, that case really was about whether Citizens United, a nonprofit corporation that accepted just a little bit of corporate money, whether it could use their treasury accounts to run a movie that would be displayed over on-demand television. It's not really what the Bipartisan Campaign Reform Act was intended to target. So there were much narrower ways to resolve this case. And when the case went up to the Supreme Court, the Citizens United, the party challenging the law, didn't ask that Austin be overruled. Citizens United hadn't asked the lower courts to overrule Austin, and so the government, in defending the law, didn't have an opportunity to put forth a record below on why the law was justified, why it really didn't impose a severe burden on free speech.
And the Austin case, as you have mentioned, but in case people aren't following, is the one that says this thing of you can't spend from your treasury on federal political
That's right. Austin is the 1990 case that had upheld a very similar Michigan
and
law.
that what Citizens United was asking for was not that. The case wasn't about that. They didn't ask for that. And so, as I recall, they were quite surprised when...
Right. The last day of the term last year, the Supreme Court issued an order asking for briefing on whether it should reverse its own decision. Justice Stevens, I thought, put it quite well in his dissent. When he said, 5 justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law. And that's exactly what the court did. They changed the law. They didn't interpret an unclear area of law, which is what the Supreme Court typically is doing when it takes a case and decides it. It's one problem with the Citizens United decision, aside from how it got to the court and how it sort of went against these settled legal principles is it's just wrong on the merits. This never was a ban on speech by corporations. Corporations were always free to express their views. They could lobby. They could set up political action committees and take donations from their shareholders and employees and then go out and make expenditures. It was a narrow ban that prohibited them from using their massive treasuries to come in and overwhelm and influence federal elections.
And just to sort of paint that picture, in other words, when you say they're massive treasuries, what we're saying is that, for instance, a company like Chevron, I'm not doing anything except saying that they have massive treasuries. When people pay at the pump to buy gas from Chevron, they do not assume that they are contributing to a political campaign.
That's right. And when people purchase a mutual fund and their mutual fund investment goes into a company like Chevron, they don't assume that that money will be used for political purposes that are counter to their political beliefs. That's one of the reasons why Congress has always felt that this ban on using Treasury funds was appropriate. Another reason was they were always concerned about the corrupting potential. And that leads to my second big concern about the Citizens United case. Justice Kennedy, the author of the majority opinion, adopts a view of corruption and a view of the appropriate role of contributions in democratic elections that I think is very, very troubling. And I want to read his own words here because I think they speak for themselves. Here's what he said. The fact that speakers may have and when he says speakers, what he means is corporations making independent expenditures. The fact that corporations making independent expenditures may have influence over or access to elected officials does not mean that these officials are corrupt. It is well understood that a substantial and legitimate reason, if not the only reason, to make a contribution to one candidate over another is that the candidate will respond by producing those political outcomes the supporter favors. The appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. And that's a truly remarkable statement, that it is okay for money to buy influence and access in our democracy.
On the one hand, he admits, he acknowledges that that is the likely outcome, that it isn't merely that you vote on someone, that you contribute to someone because of their previous record, that you like what they've said, so you just want to give them a chance to be in office, but that it actually is you are investing in their future actions, and he acknowledges that your contributions may influence them.
He not only acknowledges that they may, he acknowledges that they do, and he
says, he goes, perhaps the only reason.
Yes, and he goes so far. What's new is not to recognize that contributions influence politicians. I certainly am concerned that may be the case. What's new here is to say that it's okay.
And so it's
and the Supreme Court had never said anything
right.
close
and he
to that.
Also has this decision has this very strict definition of corruption, that it is not corruption unless there is a clear quid pro quo, unless there is a clear, I give you this, you do that. Anything short of that is not corruption.
That's right. But it's really hard to understand, as a philosophical matter, if it's okay to buy influence, why isn't it okay to quid pro quo corrupt someone? Why is a bribe wrong if it's okay to buy influence over someone? Yeah. Justice Kennedy has no explanation for how one can draw the line between those two things.
Let me tell people, by the way, I'm Terrence McNally. We're speaking with Grant Davis Denny. He's an attorney, and we are speaking about right now about the Citizens United decision by the Supreme Court to remove many of the limits on corporate contributions to federal political campaigns, and we will talk between now and the rest of our time with Davis Denny also about how to move toward cleaner elections and Prop 15.
Well, I'm happy to continue to talk about Citizens United. There's a lot more that could be said. I mean, I think it's inconsistent with things that Justice Kennedy had said in the past.
And as you point, I've heard you speak about it before, you point out that he actually refers to his own dissent in a previous decision as precedent, which is not so. Dissent is not precedent.
That's right. That's another strange thing about the Citizens United opinion is that it repeatedly relies on previous dissents in other campaign finance cases as its authority. But you don't use dissents as authority typically. You use majority opinions and you build upon previous decisions that are the law of the land in constructing your authority. And, Justice Kennedy's view that independent expenditures are not a threat to democracy, are not don't pose a threat of corrupting members of Congress is really difficult to believe, and it's inconsistent with the logic of his prior cases. Just last year, Justice Kennedy wrote an opinion in a case called Caperton. Caperton was a case where the Massey Coal Company had lost a case in the West Virginia trial court, and they'd gotten hit with a multi-million-dollar verdict. The owner of Massey knew it would go up to the state Supreme Court, and he also knew that there was a judge up for re-election on the state Supreme Court. So he made a $1,000 contribution to a judge he thought would be friendly. Then he went out and made a $2.5 million independent expenditure through a committee called And for the Sake of the Kids. And he got his friendly Supreme Court judge elected. That judge, after he was elected, the case ended up coming before him. That judge cast the deciding vote and did not recuse himself. And so the case went up to the Supreme Court, and the question was whether that judge had to recuse himself because of that independent expenditure that had been made by one of the litigants. Justice Kennedy, writing for the majority, found that the independent expenditures did require him to recuse himself, and here's the words that he used: because it created a, quote, substantial risk of actual bias. That is absolutely correct. It did create a risk of bias. But if it created a risk of bias for the judge in that case, why doesn't it create a risk of bias when independent expenditure committees go out and make independent expenditures in congressional candidates' elections? The answer is that if it does in one situation, it must in the other. And so it's really hard to understand how Justice Kennedy could take this absolutist extreme view that independent expenditures by corporations in legislative elections can never cause corruption.
Yeah. I'll tell you what, I am regretting the fact that I didn't choose to make this an full hour-long show, but I definitely wanted to get you in before June 8th so we could talk a bit about Prop 15. So if you would, we'll shift gears, but Grant, I will have you back on because this is my number one issue, and clearly we've got more to talk about. But Let's shift just so people, we're airing on the 16th of May, so in about 3 weeks you will, if you are an active citizen, go to the polls. What does Prop 15 do, and what are the arguments for and against?
Prop 15 does two key things. One is it lifts the existing ban on public financing of elections in California. That will allow cities around California and counties who've had political corruption scandals in the past to experiment with public financing as a means for cleaning up their systems of elections. What public financing is just using public funds rather than private funds to support candidates in their runs for election. The second thing that Prop 15 would do is establish a pilot project of clean elections for the Secretary of State's office in California. It would be for the 2014 and 2018 elections. If it doesn't work, we can stop using it then.
And it's only in those two as of this proposition, it's only in that one office,
That's
one
right.
state office. What you were saying previously was that localities, municipalities can begin to use it if they wish, but on the state level, this proposition will just make it apply to the Secretary of State's race, sort of to watch how it works.
That's absolutely correct. So what is clean elections? Clean elections works like this. It's a voluntary system in which candidates can choose to either continue accepting private contributions with all their risks of corruption, or they can take the public financing route. And if they choose the public financing route, they have to go out and collect a certain number of $5 contributions from voters in their district. In other words, they can't go out and take $1,000 contributions from individuals outside their district. They have to show that they have support within their district before they can qualify for public funding. But once they become eligible, they receive a grant of public funds to use in their election campaigns. In return, they give up the right to raise private contributions, and they agree to spending limits. The Supreme Court has upheld public funding in the past, has said that it's okay because it's a voluntary system that candidates can choose to go into. And public funding, I like to think of it as really reconciling the issues that the Supreme Court has been concerned about in the past in campaign finance cases, because it both reduces corruption and promotes free speech. It causes more speech to take place in elections because it allows more candidates to run for office without restricting anyone's speech.
So the big question, I think, two questions people have. One is, what about someone who gets enormous funding, either because they're one of these individual billionaires that like to run in California and elsewhere, and so they can donate money to their own campaigns with no limits, or just because they are backed by enormous money? How does this public funding, which has expenditure limits, how can that be a fair fight?
There's a provision in Prop 15 that takes care of that, and it's similar to provisions in other states that have clean elections. And it says that if you're a candidate who's publicly funded and you've agreed to spending limits, and you come up against a candidate who is traditionally financed through private dollars and spends unlimited sums, then you will get extra matching funds on a dollar-for-dollar basis for every dollar that your opponent spends above your spending limit. That way, candidates know that when they go into the public financing system, they'll have an opportunity to compete on a fair playing field.
Okay, and the second question people have, and this is just the objection to this, I don't even like politicians. I don't like what they're doing. I think they are corrupt. I don't want my tax money going to fund their campaigns. I hate their campaigns. What do you say to that, and what is the specific mechanism for funding Prop 15?
The mechanism for funding Prop 15 is a fee on lobbyists, which makes tremendous sense because in California, the Secretary of State's office is responsible for regulating lobbyists. So the program will be funded by lobbyist fees. It won't require higher taxes. In fact, the lobbyists have tried to attack public financing, have tried to attack Prop 15 by claiming that it would raise taxes. And a trial judge up in Sacramento recently struck from the lobbyist ballot argument that claim that it would raise taxes because it's not true.
Very good. I'll tell you, as I said, much, much more to talk about. But Prop 15 is worth taking a look at, and you decide whether you want to support it. But it's definitely worth learning more about and taking a look at. That's Prop 15 will be on your ballot June 8th. It is a step in the direction of taking some of the money out of politics. The websites that you can learn more about Prop 15 and about clean money, and what we didn't get into today, is where has clean money happened? What are the states that there is clean money?
We have Arizona and Maine that have had it since the 1990s. There are other states that are experimenting with it, but we know that it works from the experiences of Arizona.
And by works,
Maine.
what it means is brings more candidates in and so on. And I guess the question is, how did Arizona pass that crazy immigration thing after clean money?
It has absolutely nothing to do with clean elections.
Okay.
Arizona had radical politics before clean elections came along, and as we know, there's been conservative results in elections thus far this year in states outside of Arizona.
Yeah. And so the websites, caclean.org, caclean, California Clean, caclean.org, Common Cause, one word, .org, and yesonprop15.org. Thank you very much, Grant Davis Denny. Keep up your good work.